power sector in the last 3 to 4 years alone, with a cumulative amount in dispute of approximately or close to $1 billion. So maybe not quite the 6 billion that Sajad spoke about in the very beginning, but a significant amount that does need to be looked at seriously, especially in how to resolve these in an efficient way. Generally, and that's by no means the only type of dispute that arises, but generally a dispute that is commonly encountered can be summarized perhaps in 3 words, and that is circular debt crisis. That's the short answer that can take us to lunch much quicker than my longer answer, which is the way this arises is you have a number of power producers in the country, which are often privately held, either in part or in full, and they produce electricity through a variety of means, which they then sell to state-owned entities exclusively. WAPDA, NTDC. I'm going to refer to them as WAPDA as in one umbrella, but of course there may be different entities. So what happens very often is there's a contractual relationship between the power producers and the power purchaser, which are known as the PPAs, the power purchase agreements. And very often, WAPDA is in a position where it delays payment under these agreements. This is because of the 3 words that I mentioned, circular debt crisis. Essentially, WAPDA is unable to get the amount of money it needs from the final consumers in order to pay these producers of electricity. So it acts as a middleman, it is unable to get sufficient funds, and therefore unable to pay the power producers sufficiently, as it is contractually obligated to. And what happens as a result is, because these power producers have one exclusive customer, and that is WAPDA or NTDC, however you may want to call it, if WAPDA doesn't pay, they don't have sufficient funds. And if they don't have sufficient funds to operate, they may not be able to produce electricity as they should under the contract. And then what WAPDA does is it says, you're not producing the electricity you should, so therefore I will ask you that you pay me a penalty of X amount in liquidated damages. That is not the only, by any stretch of the imagination, but a typical dispute in the power sector, I would say.
Okay. Well, you've touched on already some of the parties that are involved in power disputes. Sami, would you mind telling us more about all the various parties that you usually see in power disputes for those that maybe haven't dealt with power disputes yet?
Yes, thank you, Antonia. So usually in a power dispute, one needs to be conscious of all the players in the power sector. From a power producer point of view, if you are a power producer and you want to set up a power plant, you will obviously have to deal with parties from the government side, parties from the private sector side. From the government side, particularly, the first party that the power producer obviously is directly contracting with is your power purchaser. What the cases that Dimitrios was talking about are cases which arose prior to 2015 when you had WAPDA acting as your power purchaser, as your power distributor, and in charge of transmission as well. Subsequently, this model got unbundled, and today if a power producer would have to not only enter into a contract with the power purchaser and the national transmission dispatch company, and they would be directly contracting with the federal government, who would be guaranteeing the performance of the power purchaser. Other than that, obviously, depending on the type of power plant, if you have the fuel sources oil or gas, then the power producer would be contracting with national utility companies such as the SUI Northern Gas Pipeline or the SUI Southern Gas Company. So those are the main government parties that today you would see a power producer contracting with. All the contracts would obviously be interlinked, and that's something that is important to keep in mind. And as we later discuss, there are issues that will arise out of such complex transaction documents.
Thank you, Sami. I think that's very helpful to set the scene. And just in line with that, Samar, would you tell us more about how power projects are structured and what sort of contracts govern power projects?
Sure. I'll take the opportunity to step even further back, which is perhaps a useful thing for those in the room who are firstly new to this area of dispute work, and secondly, new to the profession, because for those of you who practice in this country, the next 20, 30 years, i.e. your careers, will see a lot of disputes in the power sector. So I just want to step back and see what is the menu of issues that can arise. Broadly speaking, this is international. It's not specific to Pakistan, but as an emerging economy, we will see all of these types of issues. Broadly, there are three stages and three types of issues that lead to disputes, and it's important to just think about them before we delve deeper. Firstly, you have the development and conception stage, where you have issues like bankability, issues with financing, and questions of lender protection, guarantees from OEMs, the original equipment manufacturers. So getting the equipment which you need to construct the facility in place, and all kinds of issues related to that. Secondly, in the same development and conception phase, you will have issues relating to consents, licenses, permissions, which often involve a government element. And this is where you can get yourself into an overlap between the pure commercial arbitration side of things and investor protection side of things. But we'll look at that perhaps in more detail a bit later. The second stage is once you've developed and conceived the project, you have the construction of it itself. Now we will see in this country, as we have seen in many parts of this region, an increasing amount of disputes relating to construction projects themselves. Now, power disputes in the construction industry are specific for a number of reasons. You're not just building a structure. You are building a structure that needs to be connected to the grid. You're building a structure that requires materials coming into it, and you have a number of parties involved. And the greater the number of parties, the more issues you're going to have. You're going to have to start to think about, well, do we want one contractor to do the whole job, which is the sort of structure that you see in solar power plants, or do you want to have different contractors doing different bits? And if you have more parties, you will have more issues and more complexity. And the last thing before I hand back to Antonia, the last stage is once the power plant, whatever kind of power plant it is, it's built, it's the operation. In the operation, you have, again, two sorts of disputes. One obviously is what's been already touched upon, the money issue. You're trying to make money out of the sale of power, and the issues around PPAs, etc., which are well known to many in the room. But also issues between the operators and the owners of the facilities in relation to, well, you agreed that you would be able to produce this much electricity, you are not meeting this. The owner says to the operator, and the operator says, well, that is because I'm not getting the right kind of raw material. And issues between operators and owners will also increase as the complexity of the sources that go into power plants increase over time.
Thank you, excellent. I mean, that's, those are the kind of disputes you see in the power sector. Dimitrios, if I could hand back to you, before going to formal dispute resolution proceedings and to arbitration, are there any ways to resolve power disputes? Are there any recurring issues relating to sort of pre-dispute mechanisms that parties can enter or use?
Yeah, absolutely. I think it's useful to think, as many of you will know, there are certain power policies in Pakistan, the 1994 power policy, the 2002 power policy, 2006, and so on and so forth. And these spawn power purchase agreements, which are very similar in terms of the provision. And the reason why I make this short introduction is because under these agreements, you have a fairly standardized menu of options if you have a dispute as to where you can take it. And of course, one of them is negotiation. You always have that in these complex commercial contracts. And you also have expert determination and arbitration. So in negotiation, in my view, I mean, these are long-term contracts. They can be for a duration of anything up to, from 15 to 35 years in some cases. So negotiation is obviously always a good idea because you want to keep operating, right? And you don't want to enter into a dispute that will affect the very investment, which is the power production facility. So it's always a good idea to try and negotiate. But in my view, some of these more endemic disputes, like a dispute relating to the circular debt issue that Pakistan has been facing for a few years, they are harder to resolve by negotiation because they will recur. Even if a negotiated solution is arrived at, the problem will likely arise again in the future, and it's endemic in the industry, so it's difficult to treat it as a one-off. So expert determination is another option which parties can look at, and it's very important, I think, to keep in mind two things. First and foremost, expert determination is a creature of contract. And unlike arbitration, it's not something that has a statutory context around it, a statutory backing. And that means even if you have an expert determination that is in your favor, whether you are the producer side or whether you are the purchaser side, if the other side does not respect it, then you will still likely have to go to arbitration to enforce that expert determination. So it's of course an option, it's something that you can do to speed things up, and it's something that in my view, in my experience, is very, very helpful when you have more technical, narrow disputes that you can actually resolve in a satisfactory fashion quickly through an expert determination process that will last a few weeks. But if you have something that's very complex, like the liquidated damages problem that I described earlier, it's very likely that this will end up in arbitration one way or another because it's a dispute that raises issues of contractual construction, complex factual issues that an expert may have a hard time resolving. Now, having said all of that, the 9 IPP's case, as I'm sure many of you know, was a case where there was an expert determination. The expert determination was on such a complex dispute, so we can discuss that later. But it's certainly an option.
Okay. Moving on to arbitration. If you've moved past your expert determination stage, if you didn't have that stage, you've got an arbitration. Samar, I'm going to come back to you. What kind of technical issues do you encounter? What kind of issues arise in practice during arbitration proceedings in your experience?
Well, there are two questions there, and I'll take them in turn. One is what kind of technical issues arise, and the other is what kind of procedural mechanisms there are to do. Well, listen, a power plant, it goes without saying, is a complex thing. You will have, as I did recently, you will have lay witnesses who are leading scientists in their field, giving evidence in their language, by which I mean engineers, which is a language which is different from the language that those of us who chose careers in law tend to speak. And so you need to translate an engineer's language into a language that the tribunal understands. That's one issue that happens very frequently. The second issue, and this is a result of the first, is that often at the pleading stage, at the very beginning of the dispute, you don't actually understand what exactly the technical issues might be. In a recent case, we were dealing with what both sides thought initially was just a structure, a steel structure. Think of it as a massive oil refinery. But ultimately, the issues were about seismic engineering. The earth moves under the structure. You need an entirely different field of expertise. Now, unless you engage proper subject matter experts at a very early stage, which is something that clients don't like because it increases the cost for them, you will end up going down the wrong route often. And so you have to convince the client that even if you are engaging an expert early on, an electrical engineering expert, a leading firm of forensic quantum experts, any kind of experts, you need to engage them early on so that you can understand what the issues are, and secondly, what the case is worth really at the end of the day. On the procedural side of things, just picking up on what was said earlier, expert determination is a very, very good thing. You should try and have that in your agreements to the extent that you can. But it's also important that decision makers, people who are actually deciding, well, which of the many of dispute resolution processes to adopt, the understanding. So it goes to capacity, it also goes to technical understanding. But you need to get all of those things in place at a very early stage, because a big infrastructure dispute can get out of hand and very expensive very quickly if steps are not taken at a very early stage.
Thank you. And just a brief comment that if anyone needs to take a break for prayer, you're of course very welcome to step out at any moment. And thank you very much, Samar. It's interesting what you say at the end, relating to efficiency in a way, and maybe that's a good point for me to pass over to Osman. We are of course very fortunate to have you here from the Attorney General Office, and I know you wanted to say a few words about recurring issues from the Attorney General's perspective.
Indeed. Thank you everyone for being here. Thank God it's Friday, and yet you were here listening to me. Well, I have the benefit of hearing everyone speak before me, so I'm going to try and connect with what has been shared and couple that with what I would also like to express to you and highlight, which are avenues that law firms, both international and domestic, need to keep in mind. So please do nudge me if I go over time. But if I can actually just go straight into the matters that we've also slightly touched upon, I think it was both Sami and Samar who referred to the numerous parties that are part of an agreement, that are part of what the engagement entails. Now, the thing which is essential for law firms to understand, and this is something that both domestic and international firms can keep in mind, is that when you are working with the government, there is inherently going to be the element of communicating and working with a number of agencies. Now, these agencies could be government departments, they could be regulatory bodies. Have the most expert person come in, attend these meetings, who may not come at the next meeting. That's how bureaucracy works. Or otherwise, have a legal background and do not have a legal background. So varying levels of expertise, varying institutions, varying agencies on the same table. It is the duty of, I would say, the law firm engaged, first and foremost, to keep two very essential things in mind, and it's quite extraordinary how easily this is forgotten. One, make sure your clients understand what you're trying to express. Recently, I was in a meeting, interministerial meeting, and as soon as ICSID came up, they said, well, gentlemen, since this is ICSID, so I'll just address the colleague of ours from the Office of the Attorney General, as well as that from the Ministry of Law. And essentially, the law firm there excluded every other agency that was present in listening into what was going on. So someone had to step in and express what ICSID was so that everybody knew what it is, and then the agencies involved could chip in. So if at the outset there's not enough communication going on between all stakeholders, then we increase the risk of a systematic failure in achieving an output that would have been a win-win situation for all parties. If I can actually carry on that thought, again, this is for both domestic and international law firms. Perhaps more for domestic, if I can be a bit honest. I have noticed that there is some degree of reluctancy with being forefront with bringing bad news. Essentially, sometimes law firms would like to toe the government's line. They would not like to ruffle feathers. They would not like to go against the grain. And I'm not going to cast blame on only such participants in these negotiations. I completely understand that the bureaucracy is also going through a learning process. But having said that, it is important to keep in mind that when we are advising as lawyers, we need to keep in mind that we may be the bearer of bad news. And it's important to be that, rather than to toe the line and let things go the way they were, as they have perhaps for many years. So this is with regards to dealing with the number of agencies that you have on board and making sure that the process kicks off at the right tone so as to reduce the chances of failure. And if I can then quickly move on to, I believe it was, yes, perhaps it was Samar or one of my colleagues, they did mention what things can go wrong. I cannot stress this enough. This was discussed in the earlier morning's panel as well. Due diligence is something that has been lacking. I personally know of a case where Pakistan has been successful in gaining a decent amount in terms of damages. The company itself is registered in the Cayman Islands or somewhere around there. The owner of the company has very conveniently assigned all his assets to his wife, and much before this company was ever formed. Now, there are two questions here. One, was it really smart of everybody, perhaps? And may I just say the lawyers too, because they are in the driving seat, they should be if they're not, to suggest and not raise any red flags. And then the second thing is, there is not going to be an effective enforcement, even if you win such cases. How do you go about and get what you rightfully won in, say, a shell company that's registered in Mauritius, or some chap who says he's really poor, but his wife lives in an exquisite neighborhood of London because that's their family home. So it's those things to keep in mind. I mean, am I still good on time? Okay, because I could carry on, but then contractual matters are another thing that we can keep in mind. When we are putting contracts together, we need to bear in mind some very essential things. For example, you know of sovereign immunity and how often that comes along. And I've worked for other governments as well. I've worked for the British government, I've worked for the American government. I can see sovereign immunity seems to be something that a lot of, parties presume that they should take for granted when it comes to Pakistan. Whether or not that's smart is another thing. But here's what I would suggest law firms should keep in mind when they are advising the government. They should advise on notes such as performance guarantees. Why can we not have performance guarantees put down in contracts where we can have investors provide bank guarantees, where we can have insurance companies back what the investor is proposing, where perhaps if there is such a shell company that looks like it could not fulfill its obligations because its balance sheet hardly compares with the net value of the project that they're diving into, then we should perhaps ask the parent company to step in and give guarantees. And this is all of those things that we could do prior to anything, which I finally say in frank terms, before things go south. This is the contract development stage. You're connecting with the client, you know your client, you're making things simple for them to understand. You are culturally aware of how the bureaucracy works in a developing country like Pakistan. You make sure you've got the right attributes in the contracts, you've done your due diligence. Things could be a lot different. So again, this is two sides of the same coin. The success that we can ensure and to prevent such arbitrations against the government is going to be a team effort. And this is not to hold the feet of law firms to fire, but it is to express the views that are important. And I mean, again, because you see, since I am representing the Office of the Attorney General, so I cannot quote explicit cases. But with regards to expert determination, I mean, there is a view about that too. We could say that the expert in a certain case stepped over their terms of reference. They exceeded the terms of reference, and whether or not the courts agree with us, but perhaps that would be one of the reasons why a certain negotiation, anything prior to the arbitration, did not work. So that's just to highlight a few things and put out for everybody's consumption. But thank you. I surely have taken a lot of your time. Thanks for your patience.
Thank you. And I think these insights are going to be very interesting to many of the lawyers here working with the government. And I'm sure some will pick those up with you again during lunch. But looking at the other perspective of working with the government, Sami, are you able to share with us some of the recurring issues that you see for contractors trying to enter into contracts with governments relating to power issues and looking at that perspective?
Yes. First, let me say that I haven't represented the government. I'm not sure if Usman's criticism applied to me. So I have had the opportunity to represent a few power project companies in the renewable sector. I also had the opportunity to work with some clients in the oil and gas sector, larger energy sector. What I want to talk about is something that really interests me, and I'd love to get views from other lawyers, in particular Mahmoud Saab, who's we all looked up to, a senior lawyer. The issue mainly is of arbitrability. We all know that the power sector, the natural resource sector, oil and gas, these are areas in which disputes quite often have a public interest impact. It has public implications. If you immediately look at RECODIC or the rental power project, the reason why, and yes, we can debate about whether the Supreme Court's approach was right or wrong, but we have to acknowledge that the Supreme Court did interfere is because these issues related to the public interest. Now, what is important for both government parties and private parties within the power sector is to recognize that the area is regulated. We have what's called the National Electric Power Regulatory Authority, NEPRA, which regulates this sector. So when parties conclude a power purchase agreement, for example, a lot of the issues within that are issues determined by NEPRA. One primary issue is your tariff. So the NEPRA will issue a tariff determination. It also has power under the NEPRA Act to set out terms and conditions which parties are required to incorporate in the power purchase agreement. And I've certainly experienced, and I believe others have, that at times a dispute arising from the contract will relate to interpreting the tariff determination. Sometimes the lines can get really blurry. For example, if one party is asking or requires relief nullifying perhaps the tariff determination. Now clearly that is something that is outside the scope of an arbitrator's jurisdiction. Parties need to be careful what issues lie within the jurisdiction of the regulatory authority and what issues are arbitrable and lie within the jurisdiction of the arbitrator. I've been involved in a case in the oil and gas industry where the petroleum concession agreement, which was agreed between a petroleum producer and the federal government, contained obviously a clause relating to the price, and there was also an arbitration clause. Many Pakistani lawyers will know that the regulator has exclusive jurisdiction to determine wellhead gas price. So an issue arose as to whether or not the dispute regarding price in the contract is something that the arbitrator could decide on. Some may say that it is perfectly acceptable for the arbitrator to rule on that issue, and then for the regulator to subsequently make a decision on that. I am of the view that, and this is in line with the case law in Pakistan, where a statute specifically grants a special tribunal or special court jurisdiction, those matters which fall under the tribunal's jurisdiction are then considered to be non-arbitrable. And you have your regular examples of in the insolvency proceedings, the IP matters in Pakistan and in some other jurisdictions are also considered to be non-arbitrable. So for players in the power sector, I think that is an important issue to consider, whether regulatory issues arising out of a PPA, whether they can be arbitrated or whether they are to be decided by the regulator. Another example I want to give, which came out of the power sector, was an interesting case. This is the K Electric case versus the Federation of Pakistan. For those of you who are interested, the citation is PLD 2014, Sindh, page 504. Makhdoom Saab was earlier referring to an esteemed judge who's now Justice of the Supreme Court, Munib Akhtar. He authored this judgment, and the issue before him was the dispute between the K Electric and the Federation was that K Electric wanted to draw about 650 megawatts of power from the National Grid Company. What had happened was that in Pakistan there is a Council of Common Interest, a constitutional body, which is or sits outside the federal government. They decided that 650 megawatts could not be withdrawn, and they reduced it to 300 megawatts. For that reason, the government party was in breach, could not comply, could not grant the power that was required by K Electric. When the matter went before the Sindh High Court, the government side applied for a stay of proceedings in favor of arbitration. Keeping in mind that this was the domestic arbitration that was agreed, but the judge ruled that because the issue in this dispute is whether or not the decision of the Council of Common Interest is valid, it was a constitutional issue and therefore was non-arbitrable. So at times you will find, just like there are regulatory issues which can be non-arbitrable, you will find within a system certain constitutional issues which cannot be arbitrated, and the right place to settle such disputes are the courts. So that was very interesting. What is interesting, and I put it to all of you, is what would happen if the arbitration agreement provided for rules of an arbitral institute, and the seat was somewhere in Singapore or London, and therefore the agreement being an international arbitration agreement. Would the Pakistani court rule in similar fashion? Most likely, but most probably the arbitration would still go ahead in the foreign seat, and what would likely happen is if there was an award, it would be unenforceable perhaps in Pakistan, possibly. But it's important for such arbitration clauses to be tailored very carefully, especially when you have complex project transactions all interlinked. Dimitrios spoke about how one breach can cause another breach, so there's definitely a knock-on effect when it comes to these type of projects. And when it comes to trying to focus on issues which the arbitrator can deal with, it's helpful for parties to consider carving out some issues within the arbitration clause. So those are my thoughts on that, and I'm happy to take questions.
Thank you, Sami. Before opening up to questions, just one last question to Dimitrios. You mentioned earlier you wanted to expand on the on your experience in the power sector here in Pakistan and sort of further recurring issues that you've seen, such as under the IPP, the NTTC dispute. Is there anything further that you wanted to share with the audience?
Well, I didn't really want to, but since you put me on the spot, there is actually one issue that Samar touched on, and I think is important to raise, is when you're looking at the menu of options as a party in one of those agreements, and you have a dispute and you want to have it resolved, is before you can go to arbitration, you need to ask yourself, are the pre-arbitral steps mandatory? So is going to expert determination or negotiating with the other side mandatory? Because if you don't pose this question and you just go to arbitration, let's say, you may very likely face a challenge to the arbitral tribunal's jurisdiction or the admissibility of your claims, and that of course delays the arbitration and you get into a jurisdictional phase and so on and so forth. So that's definitely an issue that I've seen in at least 4 arbitrations that we've been involved in, where one side argues that you have to go to the expert, the other side argues you don't really need to go to the expert. The other thing I'd say as a takeaway is we've spoken a lot about how these power disputes raise recurring issues, and I think that's at an appropriate level of vagueness that it can be correct. But once you start looking into each dispute in detail, it becomes quite clear that what you thought is exactly the same issue arising in all of these disputes actually may not be the case. One very easy example is the terms. Sami mentioned there's back-to-back contracts that these power producers have between the fuel supplier, which could be PSO, it could be a gas company, and the contract that the power producer will have with the power purchaser. And of course, the terms of these contracts can play a huge role in the cash flow of the power producers. So, for example, at what point in time does the power producer need to pay the fuel supplier? Do you pay the fuel supplier in arrears? Do you pay the fuel supplier in advance of providing fuel? That can have a huge impact on the cash flow, and therefore a huge impact on how the dispute will arise if the dispute is that the power purchaser, WAPDA, NTDC, whatever the entity may be, is not paying on time. So even though the disputes look similar, and in some respects are of course similar, we can't, common lawyers have a fixation for precedent, and we need to kind of rid ourselves of that fixation if we want to deal with them effectively. Yeah.
Fair point. I have some more questions, but maybe we'll open up to the floor for the time being and see who's got any questions in the audience.
Hi, my name is Hassan Raza, and I work for a local law firm called Moderator. I have worked for almost under the three power policies, 94, 96, and the 2002 power policy. And my link with the power sector is that I usually represent Pakistan State Oil in on behalf of the fuel supplier, and I represent them in many disputes. In the last decade that I have represented or looked after the interests of the fuel supplier, what I've seen is that the security documents that have been provided through the power policies, which is the implementation agreement, sovereign guarantees, PPA, FSA, all of these give a bit too much. IPPs get capacity payments unheard of. They get many incentives, the package of incentives, which apparently is important at that point in time. They've been given to them. Those security packages have now been they've become very controversial, and they've been misused. This is why issues like circular debt and all these issues, fuel supply issues, are raising up. My first question to the panel is, how can we make these incentives more realistic so that these issues of circular debt, exclusive fuel supply on unheard of rates, they can come in real terms. That's number one. Number two, all these security documents, they're not subject to a lot of discussion. You can't really change them. They're under the power policy. You take them and you take them. The arbitration clauses over there are very clear, as Sami has stated. However, I have seen IPPs going into Supreme Court for circular debt, going into High Court. Just about a couple of weeks back, I won 4 petitions against 1994 power policy IPP providers who challenged exclusive fuel supply in constitutional jurisdiction. That is unheard of. The High Court, 3 articles petition, again, an answer to Sami that yes, Pakistan courts will not take cognizance over arbitral agreements. So that's my second question. How do you let these IPPs, or how do you curtail these IPPs misusing our system? Thank you very much.
I'm going to try to take this one. The first question related to how realistic you can make the terms in the security documents. That's quite a loaded question. It's more of a policy issue, isn't it? I believe the government believes that's the right way to attract investment. Capacity payments, yes, that's a huge burden. A lot of payments need to be made, but you need to make power plants available and ready to provide you with power. Otherwise, we know what's been happening in Pakistan, serious load shedding issues. With regard to the second issue that you touched on, the non-negotiability of certain model agreements and standard agreements, maybe my friend Usman can tell us a bit more about the mindset of the government, but this is how the bureaucracy works. I was involved in 3 LCI arbitrations, and what we discovered was that the EPAs, standard EPAs, although the counterparty is your central power purchasing agency, but the negotiations were conducted by the Alternative Energy Development Board. And the Mosle agreements were approved by, I believe, it was the Economic Coordination Committee of the Cabinet. Once the ECC approves that, no government official wants to touch those agreements. If a party wants to propose a change in the Mosle agreements only because of perhaps the size of the power plants or the structure, is not really open. And this causes real difficulties. Investors who are interested to still back the contract will still go ahead, and then disputes will later arise when it turns out that you agreed to something that you did not intend to. The High Court jurisdiction question, we all Pakistani lawyers really scratch their head, right? There appears to be precedent about how contractual issues cannot be brought about in the constitutional jurisdiction. Contractual disputes should be resolved in accordance with the contract, either in the courts if there's no arbitration clause, or if there is one, then through arbitration. But courts have and are known to commonly ignore precedent and create exceptions. The difficulty that I think about, and I would really like to hear more from senior lawyers, is the courts in Pakistan don't set a criteria upon which an exception can be created. So if there's a general rule that in the constitutional jurisdiction you cannot allow this, if you're going to create an exception, what is the criteria? There needs to be certainty in the law for us lawyers to advise our clients, this is how your case is going to turn out to be. And I think this relates to what Usman was earlier talking about, is that, the due diligence, how well are lawyers prepared and how forthcoming they are with clients as to what their chances of success are going to be. A lot of it has to do with the fact that it's simply unpredictable. Notwithstanding that I agree with, obviously, those sentiments, one should tell the client absolutely the truth about how likely he is to win or lose a case. But those are my thoughts on that.
Right. Well, I'll just give you a general idea of what my thoughts are, and perhaps not to break it down into specific questions and answers. See, now my view is that traditionally many things may have been done which weren't the right way to do it. Again, I'm not going to be quoting any cases. What can we do about that now? How do we move forward? How do we learn from our mistakes? And this is going to involve both the bureaucracy as well as the councils to engage in a more constructive manner. And I'm not suggesting that anything that was prior to it wasn't constructive, but we can surely improve upon the manner in which we do work together to get the best outcome. If it is a win-win, if a negotiation is a win-win, it has more chances to succeed than one side becoming the winner, the other the loser, agreeing to it at that point in time, and then things falling apart 15 years later. So, well, again, this harkens back to what I spoke at the outset, which was a degree of complacency can become an issue. A degree of not understanding the clients and not perhaps translating matters as appropriately as they can be will be an issue. Some degree of complacency can be an issue. And I am confident that where we in the government have had our share of learning, specifically with regards to the cases that we've dealt with in the last 10, 15 years, as have the domestic law firms as well. And may I just very quickly say something about domestic law firms, because I was keen to share this. The gentleman who spoke in the morning, a very learned colleague, Professor Naqvi, made a very good recommendation. I do believe that the capacity of domestic firms to service the government of Pakistan can be improved. I believe that there is a learning process. And what is the learning process? How do we engage with that? Here's a suggestion. What if I have a law firm in Pakistan, a domestic law firm, that engages a foreign legal expert, not the firm, a legal expert, as part of a consortium. So for me, sitting where the government is, I engage with one entity. That one entity is a domestic firm. It has a foreign legal expert, an off-counsel, and it has other experts, perhaps technical experts, to advise on specific matters of law. And essentially what we are doing here is we are reducing the layers that can create confusion and delays. Conversely, if there's another firm that the government hires, which is sitting somewhere in London or in New York, they hire a domestic firm in Pakistan. Now, suddenly the domestic firm is reaching out to us, so is the international firm, and the international firm is connecting with the domestic firm, and then the domestic firm is reverting back to the international firm, and they come back to the office of the, there's just going to be needless chaos. So there's certainly room for learning and improvement, and I would think there's much to gain here. Let's have an optimistic view to how we can learn and improve things. And yes, that in effect is my way of looking at things, to learn, to improve our skill sets, and then to move forward.
Before the next question, Mr. Makhdoom Ali Khan, did you have any comments on the power issue more general that you wanted to share? I see you're making notes. No. You're right. Well, in that case, any other questions from the audience, please?
My name is Abbas. I'm Director Legal PPIB, who is responsible to actually create the security factor we are talking about. And I put up these summaries with the ECC for the approval. So I just want to make a few clarifications. Actually, some of the stuff have been mentioned that needs some clarification and perspective. First of all, whenever the security package is created, there is a wholesome, consultation process is done, and not just inside the government, but with the stakeholders as well. Like, for example, the prospectus, the sponsors are also taken into, their comments are also taken into regard. And then after consultation and full deliberations, these documents are created. And the second thing is that post-standardization of these documents, then again during the negotiations, we have still the mandate to accommodate project-specific amendments, which we generally accommodate. If, for example, they are acceptable to the government, then yes, we accommodate those comments and those amendments to the agreement. So it's not that watertight as in the government. So I just want to make this clarification so that the things are in place. Thank you.
Thank you. Just one last question over here.
My name is Arun. I'm practice here. First of all, thanks for being here. I know you went to fly many miles to be Islamabad with us. My question is for the panel, but really for you, Sami. You mentioned,
Samar. This one.
Sorry.
Samar.
Sorry. You mentioned that it was a good idea to have an expert determination in international arbitration. My experience is limited, but it's a more general question. But how do you feel about the fact that, as Makhdoom mentioned, a developing country, right? A developing country can't afford to hire an advocate for £200,000 to write an expert determination. They're going to use whoever they have on staff, right? Or more generally, the fact that ICSID, which is supposed to be a forum for justice, right, is able to award a $6 billion award against a country which is broke. Right? Forget you and me sitting here. Talk about the guys 2 miles from here living in mud houses who now per capita have to shoulder an additional $2,000 of debt nationally when they earn $500 annually. I mean, you and I both benefit from the system. We both make a living from the system. How do you and how do the other panelists feel about being part of a system that I'm not saying is biased, but let's be honest, the trend is that awards do go in the favor of the very highly endowed companies that are suing often developing countries. How do you feel about that? How do you feel about the industry in general, the consultants, the lawyers, the arbitrators, who often make a lot of money from disputes against nations that are broke like ours?
There are 2 questions there. One is related to something that I said. One is broader. And I'll answer the second question first. Yeah, I feel terrible about it. There's no other, as lawyers, we obviously, we are in this business to earn a living, but we are also in the business of giving good advice to our clients. If our clients happen to be the companies, well, we have to give them good advice. If our clients happen to be the state, well, we have to give them good advice. And the good advice happens to be, well, go and get what's your right, because the state hasn't done its job properly. Well, that unfortunately is the advice that you have to give, and sometimes you feel bad about it. I've myself done cases acting for states where we've had, and by the way, Pakistan is not the worst. Pakistan is not also, no, by some distance, not one of the worst. Pakistan is also not inherently incorrigible. And so it's things like today, you build capacity in the jurisdiction so that you don't have to go to expensive foreign lawyers. You improve institutions in the country, and this is true for Pakistan. This is true for all emerging economies. So yeah, when you're on the other side and you feel, well, oh wow, okay, a taxpayer in a poor country has to pay money. Well, yeah, you do feel bad about it, and you should. To your first question, which goes to the question of experts. Well, listen, it's actually tied to your second question.